Hello. In this video we're going to look at coincidence both in terms of time, so the fact that all of the elements of an offence must coincide at one point in time for that offence to be committed, and also coincidence in terms of object, or more commonly referred to in relation to transferred malice. So if I intend to hit one person and accidentally hit another, or if I intend to steal one object and accidentally steal another, or whatever it might be, to what extent the criminal law allows my mens rea, my intention, to be transferred from the thing that I was trying to hit or trying to steal to the thing that I actually hit or I actually stole in order to find liability. Now, these issues are quite fiddly, they're quite complex at times, but in the vast majority of cases they simply don't apply, or they don't apply in the sense that they need explicit discussion. And so this is why within the textbook we separated them within chapter 4 and looked at them as an interaction between actus reus and mens rea. But it's useful just to give a brief overview within this video as well. So first of all, in terms of coincidence of time, and I think this is one of the most important ones, where often students get the wrong idea and feel that they've discussed actus reus, they've discussed mens rea, and then they have a separate discussion about coincidence. Even if the coincidence, if everything happened at the same time, is very obvious, they still feel like they need to have one or two sentences just to make that very, very clear to their reader. And the point I want to make here is that actually in the vast majority of cases that's unnecessary, and that your application of the coincidence principle should be clear within your analysis of both actus reus and mens rea as they go along. So let me explain this to you in a bit more detail. Let's say within analysis of any crime you should always start by applying the actus reus first. You never apply mens rea first. The reason for that is because when you look at the actus reus, you're placing the crime in terms of space and in terms of time. When you're analysing where, for example, Sally kicked John, you're looking at when that kick happened. That places the offence, or the potential offence, at that moment in time, and within that geographical location if you're then thinking about jurisdiction, etc. afterwards. So having placed the crime, having looked at the actus reus and identified it at a particular point in time, when you go on to then explore the mens rea, i.e. what is the mens rea required of the crime, and then did the defendant have that mens rea, you're not asking in a general sense of did they ever have that state of mind in their lives, but rather you're asking a much more specific question, which is did they have that mens rea at the point they completed the conduct within the actus reus of the offence. Now that is a question of coincidence. You don't have to use the terminology of coincidence, but simply by making it clear when you're applying the law within your problem question that you're asking the question about mens rea specific to that point in time, you're satisfying that requirement of coincidence. You're satisfying it just inherently within your discussion. Now, when you're asking if the defendant had the mens rea at that point in time, there are three potential answers. The first one is yes, they did have the mens rea, and at that particular time. In that case, wonderful, you found liability and you can go on to look at potential defences. The second answer might be no, they didn't have the mens rea at that time, and actually they've never had the mens rea required for the offence, and your answer there is, therefore it looks like there's no liability, unless of course you might get into the sort of constructing liability in relation to intoxication, automatism, prior fault automatism, but we'll leave that to one side. Your basic answer is no mens rea, no liability. The third option, and this is the only time explicit discussion of coincidence is required, is where your answer is no, they didn't have mens rea at that specific point in time, but it does look like they had the mens rea required for the offence at a different point within the factual scenario, either before they committed the actus reus or after they committed the actus reus. Now in this scenario, you need to say, okay, there looks like there's a problem here for a lack of coincidence. But there are ways in which the court have tried to reinterpret the conduct requirement within an offence in order to avoid those problems, in order to find coincidence. So you would look, for example, is there an alternative conduct element that we could use? If we were focusing on an action, for example, is there maybe a later omission that we could use where there would be coincidence with the mens rea at that later point? Or are there multiple actions and we could focus on a different action to find coincidence at that point? Or indeed, as we see from the case law, is there a way we could reinterpret the defendant's action and stretch it, either by saying it's a continuing act or by saying there's a series of acts which we can link together? But basically we're looking for ways to expand or relocate the conduct of the offence in order to find coincidence with the mens rea. But this is the only time you need to explicitly engage with that case law. If the answer is yes, there is coincidence, then we simply have liability. If the answer is no, there's no mens rea at any point, then the answer is there's no liability. It's only that third option where you need to explicitly engage with the case law. There is mens rea, but it doesn't seem to coincide. Moving on to the other one I mentioned, this is more coincidence in terms of object, or more commonly referred to as transferred malice or transferred mens rea. And here again, the important point to remember is you only need to explicitly engage with this case law if the point comes up within your problem question, if there's a reason to do so in terms of controversy within your problem facts. So let's say, for example, a classic scenario where you might imagine transferred mens rea would be where there's a pub fight, I swing for one person, Ted, who I want to punch, but I miss and I hit Paul standing next to him. Now in this scenario, we've got the actus reus of an offence against the person, I have hit Paul, but my mens rea isn't focusing on Paul. I didn't intend to hit Paul, I intend to hit Ted. So in that sense, it looks like there's a lack of coincidence of object. I've hit one thing, but I intended to hit the other. Now, before we start discussing transferred mens rea and solving the problem that way, it's also worth thinking that actually most offences against the person don't require an intention, they simply require recklessness, i.e. foreseeing a risk and going on to run that risk. So our first question we can ask is, although I didn't intend to hit Paul, when I was flailing around in my pub fight, did I at least foresee a risk that I might hit Paul, or that I might miss and hit him, or I might ricochet and hit him, or I might harm him in some way? If the answer to that question is yes, and I did foresee a risk, then we don't need transferred malice. We can simply say, I have hit Paul, and I foresaw a risk that I was going to do so, and that in itself is likely to be enough for many of the offences against the person, such as section 47 and section 20. It's only if we can say that I don't have any mens rea in relation to Paul that we might then look for transferred malice and say, okay, actually, through this doctrine of transferred malice, the courts have developed a way for me to transfer my mens rea from one defendant to another. But in the vast majority of cases, actually we don't need it. And these kind of more creative legal fictions within the law should tend to be seen as a last resort. Only use them, only discuss them explicitly if it's actually necessary to do so. Thanks.